May it please your lordships. Lordships, I beg to mention a criminal appeal, my lord, which had come up in the month of January for admission for the first instance. Appeal was admitted and the LCR was called for. My lord, any time convenient for your lordships for orders, my lord. Whether
Can it be listed before this court?
We will list it before this court, my lord.
Can be listed.
Yes, my lord.
Okay, next week.
Orders, my lord. Next week, anytime your auspice convenient. Deeply obliged, my lord.
Yes, ma'am.
Lordship, item 10, I have yesterday given written
Okay.
only for the day, Lordship.
Ms. B. Sharma, learned amicus curiae for the appellant, has sought an adjournment and had submitted that a mention memo to that effect has already been circulated yesterday. Full stop. MS A. Begum, learned addition public prosecutor, has submitted that the state has no objection if the prayer is allowed. Full stop. The prayer is allowed, is the case after a week.
Pray for listing of a criminal appeal, Lordship. It was admitted on 20th of May, and in LCR was called for an returnable 4 weeks. Next week, Lordship. Obliged.
Waiting list for admission. Item number 1.
May I please, Your Honor? In this criminal appeal, conviction is under section 302 and the
Hart, MS, and Hassan, learned legal aid counsel for the accused appellant, and MS. A. Begum, learned additional public prosecutor for the respondent state. Full stop. This criminal appeal is directed against a judgment dated 19/1/2024 and an order on sentence dated 20/01/2024 passed by the Court of Learned Sessions Judge Kachar at Silsor in Sessions case number 107 of 2018 by the judgment and order. By the same judgment and order, the accused appellant has been convicted for the offense under section 302 Indian Penal Code, and he has been sentenced to undergo life imprisonment for commission, life imprisonment, and to pay a fine of rupees 10,000, in default of payment of fine, to undergo simple imprisonment for another 3 months. First off, we have perused the contents of the memorandum of appeal. The criminal appeal is admitted for hearing. The records of Sessions case number 107 of 2018 we call for issue notice returnable in so and so 4 weeks as MS Begum appeared accepted. No formal notice necessary. Extra copy. 3 working days.
highly obliged.
Item number 2.
May I please your lordship. Lordship, this is a statutory appeal, lordship, filed under section 372, lordship, against acquittal, lordship. The respondents, lordship, acquitted under section 143, 147, 148, 149, and 302, lordship.
Hard. Yes, MS Begum. Hard. Mr. Ayu Chaudhary,
Lordship.
learned counsel for the appellant, and MS. A. Begum, learned additional public prosecutor for the respondent number 9, State of Assam. Full stop. The instant criminal appeal under the provision of section 372, Code of Criminal Procedure 1973 is preferred against a judgment and order dated 18/5/2024 passed by the Court of Learned Additional Sessions Judge Bilahipara Union Trial Court in Sessions case number 102 of 2012. Full stop. by the judgment and order dated 18/5/2024, comma, the respondent number 1 to 8 who faced the trial, comma, have been acquitted from the charges framed against them under sections 143, 147, 148, 149, stroke 302, comma, IPC. Full stop. We have perused the contents of the memorandum of appeal. The criminal appeal is admitted for hearing. The records of sessions case number 102 of 2012 be called for. Issue notice returnable in 4 weeks as MS Begum, respondent number 9, State of Assam. Issuance of formal notice dispenses. The appellant shall take steps for service of notice upon the respondent number 1 to 8 by registered post with AD as well as by usual process within 3 working days.
Item number 3 for orders.
Lordship, I have, they have mailed, but still I haven't taken out the report.
What is the offense involved?
302, my lord. As per our instruction, my lord, he is paralyzed, my lord, he cannot eat properly, my lord.
Leave has been extended further on emergency medical ground.
Hmm? You are already on medical leave.
That is Lordship,
Huh?
I did not know this, my lord. You were
Take your
instructed-
instruction.
because he is not in jail.
Allowed to avail annual leave so as to facilitate better medical treatment and also to remain in proper attention of the family members. His leave has been extended further on emergency medical ground. You come back, then we'll put you on medical board.
my lord.
You come back after leave if leave is not extended. We keep it pending.
Yes, my lord.
Take your instruction. You are already out. Getting attention of your family members. Why should we decide? The authorities have already decided.
Yes, my lord. They given us leave, my lord. But total till now imprisonment is, my lord, 7 years, 6 months, my lord.
That is on merit.
Yes, my lord.
That is on merit. So far your medical ground is concerned, authorities have exercised their discretion to grant you annual leave, then thereafter extension, so that you can get attention of your family members and medical treatment. And this has been extended. As on date you are on leave, you are out of jail.
But till what?
Otherwise, we will put you on a stringent condition, medical board.
But till what date not stated, my lord? Not.
Yes. It is clear. Have you read the instruction?
My lord.
Hmm. You can, once you can get it expedited, your hearing.
My lord.
Your hearing can be expedited. You are on leave already.
My lord.
You can get the appeal
That is also there, my lord.
heard.
Yes, my lord.
That is better.
But that thing is that one bail creates a mental relief for the family and all, my lord. That is the only thing, my lord.
your application was earlier rejected,
It was rejected. ma'am.
finding prima facie ground regarding your involvement on
Yes, ma'am.
merit.
Yes, ma'am.
Only two options are available, medical, and secondly, if you have completed half of your term. That is your life.
14 years.
Of 14 years is revision. Half means
Half.
remainder of your life. So that option is not there. So
Not
this medical ground, you are already on leave.
May I pay the NITMICAP
Authorities are decided second week of or third week of September.
may I pay that the IMMCAP pending, my lord, if he surrenders and then again
Heard Mr. N.
some complication
Mahajan,
happens, my lord.
learned counsel for the applicant, appellant, and MS A. Begum, learned additional public prosecutor for the respondent state. Post of MS Begum, learned additional public prosecutor, has placed a report bearing number so and so dated 24 August 2024 from the Superintendent Central Jail Silchar. Full stop. In deference to the order dated 19/8/2024. So, as per the said report, comma, the appellant has been allowed to avail a annual leave so as to facilitate better medical treatment and also to remain in proper attention of the family members. Full stop. As per the said report, comma, the leave of the appellant has been extended further on emergency medical ground. Full stop. In view of the above information, comma, the consideration of this application stands deferred for 3 weeks.
My lord.
Full stop. Appeal. Heard Mr. N. Mahajan, learned counsel for the appellant, and MS A. Begum, learned additional public prosecutor for the respondent state. Full stop. Learned counsel for the parties have submitted that as the paper book is ready and they have received the copies of the same, comma, the appeal be listed in an expeditious manner. Full stop. Having regard to the submissions made by the learned counsel for the parties, office to list the case on it after 3 weeks for hearing. For hearing after 3 weeks on a date to be fixed by the office.
Obliged, my lord.
Mr. Mahajan, you are in it also?
Yes, sir. Same. Co-accused, man. Co-appellant. Same judgment, man.
And what is this sound? It was not, I was on 274.
8, he's on bail, man.
Mr. Mahajan, series I can be closed.
Yes, my lord. Yes, yes. 1 year, man.
This one, 274.
Convic-
See your prayer there. This is appeal along with criminal appeal 8, number so and so of 2017 for hearing after 3 weeks on a date to be fixed by the office. Both the appeals.
Both the.
Okay.
Yes,
So this can be dispensed
Yes,
with
ma'am.
close. Mr. N. Mahajan, like counsel for the applicant appellant, has submitted that since the accompanying criminal appeal from our criminal appeal number 139 stroke 2017 is to be heard along with criminal appeal 142 stroke 2017, the instant application can be closed. So in view of the above submission made by Mr. Mahajan, learned counsel for the applicant appellant, the instant application stands closed.
Obliged, man.
Judgment needed.
For hearing, Padhat method, item number 11.
Matter of hearing. No more. Pallavi বা কামক মাতক। Yes,
Well, my learned friend, if she wants to
Yes.
submit anything, I have made no submission.
any salvaging of situation?
Lordship, since this is a matter relating to circumstantial evidence, there is no eyewitnesses to the effect. Lordship, motive could be gathered from the evidence of PW1,
Motive,
motive for crime.
how motive?
Lordship, PW1. Page 11.
When motive comes, motive. In a circumstantial evidence, motive plays an important part. That part I know, but where is the motive?
Lordship, second line. No child was born to my sister. Therefore, Shamal Paul used to torture my sister. He also threatened to kill her. Shamal Paul remarried Sumitra Paul. Thereafter, Shamal started torturing my sister with more intensity. So that can be the factor as
That
regards.
is for 498A.
May not be, my lord, because the even under any other case of circumstantial evidence, since the relationship between the husband and wife was not good, and this is not a
But
case
first
which is,
linking is to be made.
and your lordship,
Yeah,
when
no, they were staying separately. They were staying separately for 3 years.
Separately,
For 3 years. It was not as if.
3 years.
evidence of PW1, 2410, accused took the deceased on the pretext of getting medically treated. 2410.
He has clarified in the cross-examination.
No, that lordship, there may be two parts as regards lodging of a fire, which he has gathered the information from Durga Paul. Regarding the other factors, it still remain. my lord.
24, 10.
10.
Let us assume. Then this is 10 days gap.
Lordship,
So detection of crime is 10 days gap.
evidence of PW5. First line. The incident had taken place during Kali Puja about 5-6 months back. So, Lordship, in the year 2011, from the Google, I could see, my lord. The Kali Puja took place, it was held on 26th October 2011. And as per evidence of PW6, incident took place on 24/10/2011.
No, that is why I have referred to section 60. From where he has gathered this knowledge? I am saying again, section
Not get any
60.
other material I could not.
Because
give you,
that is why I have
my lord.
taken it to section 60,
Lordship.
which can be seen, that is to be deposed, which can be perceived.
Source of information they have not.
That
said
is
it.
what, if the source of information is not there, that is hearsay then. Clear. PW1 is hearsay.
No, why I say there are two parts. Durga Paul as regards lodging of the FIR. Regarding the other part, it may not be hearsay, ma'am.
Regarding torture.
Yes.
But they, at
Torture
the
and
same
other-
time, they were living separately for 3 years.
But the factor still remains that he took away the disease.
Where? Who has seen it? Who has seen it? Last
Doesn't say-
seen together is a facet in a case of vital facet. In a case of circumstantial evidence. Now, who had seen it? That is why I again take you back to section 60.
Lordship, PW1, Vivas Paul. So,
No,
Lordship, just 1 minute. On fourth line, on last 24 October, the accused duo took my sister to Orang on the pretext of getting her medical treated there. And your Lordship,
that is okay. Now,
cross-examination part, fourth
Uh-huh.
line. I lost the Azahar on the basis of information received from Durga Paul. So there may be two part, Lordship. The taking
cannot
of
be that he has demolished his own case. This FIR was lost, though it is not a substantive evidence, but there he said on 24/10/2011.
My lord.
Now, he is not a person who stayed with the deceased. he stayed at a different place. And this man was supposed to go to Orang, right? Not to Dekiazuli, that he can vouch that, yes, I had seen him coming to
Oh, Lordship,
Dekiazuli.
yeah, he says PW1, at present I reside in Dhekiazul. While deposing.
Then tell him to
He
depose
has no idea,
further.
Lordship. See, his right is
Where
not
is
there.
that?
Whether your lordship will not take into account that factors.
After 12 years, he is almost,
Case diary has been sent, your lordship, at least, my lord.
we don't need what the appellate court needs. The testimonies. If the testimony, suppose evidence is contradicted by referring to any 161
Understood.
statement, then we can just for our satisfaction can look into. Now we need the oral evidence, deposed before the court, documentary evidence, whatever was presented before the court, here only FIR and it was originally only FIR,
My lord.
not even, and plus the autopsy report. Thereafter, matter was remanded back for
Postmortem.
examining the autopsy
Doctor,
doctor
yes.
and to write a fresh judgment. There are many good cases for circumstantial evidence. This is completely in my
Still,
considered view.
since wrong, although your lordship will not take into account the case diary, but since the wrong file has been.
That is too late for a day. That is too late.
I have no other.
That we
solution.
have detected. Had you detected it first hand, and thereafter submitted, okay. But this is nothing. This is not relevant. For the purpose of consideration of this appeal, I don't think that case diary is relevant. See, in what manner? Tell me.
No, lordship.
Tell me one point.
Lordship, it should contain.
We'll
all-
observe that this case diary is wrongly tagged with the case record. The trial court is to. We can observe only that much. But for what purpose we need a case diary? Tell me.
The lordship will not need that, my lord, but still.
We'll
in
rectify the
addition-
mistake if that Rajab or Rinku is going scot-free.
Lordship,
Case
but it
diary-
should, case diary should be a part of the records sent by the lower court,
Hmm.
my lord. So.
We'll observe that. We'll observe to that
Lordship.
effect.
Lordship, I have nothing to submit before
No.
this matter.
Tell me how you are prejudiced.
Exactly.
Because of.
How you are, yes.
No, lordship being a part of the.
Okay, for
Being an officer of-
hearing the appeal,
Yes.
for what purpose you are going to use the case diary? Tell me.
Because your lordship.
Because of this.
An address portion,
Which portion?
address of this one, PW1, where he used to reside. Because Shashi doesn't say anything, my lord.
He is not saying anything. He has seen it. Which part he has seen it?
No, I meant to say, my lord, I reside at present in Thekiazuli, whether his residence is nearby the
Well,
residence of
Well,
where the deceased used to reside
well,
prior to her death. So there's a possibility to see lordship, at least lordship, so that. what time-
Orang is at a different place.
But my learned friend was making a submission, my lord. See, she is trying to say, my lord, that he presently resides in Thekiazuli.
Where he used to
But my
reside
lord,
before.
the FIR itself was registered in Thekiazuli. So he filed the FIR in Thekiazuli. So at that point of time also, he was in Thekiazuli. So therefore, that issue.
Not
but
at
my
the
learned-
point of time,
Yes,
after
yes,
10 days.
because no, whatever.
What
He
is the
yes,
residence of-
because he registered the Thekiazuli.
Rongagora,
Thekiazuli, it was Thekiazuli.
resident of number 1,
Hmm.
Rongagora. FI itself says.
FIR also is given his address.
So from Rongagora to Zaganam Kilsit.
This is Ali Singha. This is Ali Singh.
What is the distance here? Better to be relevant. public.
There are better cases of circumstantial evidence.
Mala, just a small preamble. Because some other matters law should accommodate me. For some.
This criminal appeal from jail under section 383 Code of Criminal Procedure 1973, the code order CRPC, is preferred against a judgment and order dated 02/2000, sorry, 22/12/2017, passed by the Court of Learned Sessions Judge Udalguri in Sessions case number 25 within bracket capital D dash capital U bracket close of 2012. Post stop. By the judgment, an order dated 22/12/2017, the accused appellant had been convicted for committing the offense of uxoricide and finding him guilty for the offense of murder, he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000, in default of payment of fine, to undergo rigorous imprisonment for another 3 months. Full stop. The accused appellant had also been found guilty for the offense under section 201, IPC, and for the offense under section 201 IPC, the accused appellant has been sentenced to undergo rigorous imprisonment for 7 years. Full stop. It has been ordered that the sentences are to run concurrently. The case, Sessions case number so and so arose out of Orang Police Station case number 55 of 2011 and corresponding ZR case number 392 of 2011. এই LCR এই exhibit থাকাখিনি the one Bivas Chandra Paul lodged an FIR before the officer in charge, Orang Police Station, on so and so as the informant, lodged it. Lodged the first information report before the officer in charge, Orang Police Station, on 4/11/2011. Regarding missing of his sister, Uma Paul, and suspecting involvement of 3 persons, VIZ, is Fiberose. Shyamal Paul, that is the accused, present accused appellant. 2, Sumitra Paul. And 3, Sudhir Paul. As the persons involved for the murder of his sister, informant sister, as they had allegedly confessed that they had killed the sister of the informant, Uma Paul, and thereafter, buried the dead body inside a jungle near Orang Tea Estate. Full stop. The informant had inter alia mentioned that it was around 12 years. Oh, no, sorry. I mentioned, inter alia mentioned that the marriage between his sister, Uma Paul, and the present accused appellant, Shyamal Paul, was solemnized 12 years earlier. Full stop. As no issue was born out of the said wedlock, the accused appellant used to torture Uma Paul physically and mentally, and there was also threat from the accused appellant that she would be killed. Full stop. The informant had also alleged that the accused appellant had entered into another marriage and after the second marriage, both the accused appellant and his second wife, Sumitra Paul, A1, A2, A3 started torturing Uma Paul with more intensity. Full stop. The informant had also alleged that on 24/10/2011, the accused persons, A1 and A2, with the assistance of the third accused person, A3, took Uma Paul to Orang on the false pretext of providing medical treatment to her there, and it was thereafter, Uma Paul had gone missing. On receipt of the FIR, Command Officer in charge, Orang Police Station, registered the same as Orang Police Station case number 55/2011 for the offences under section 120B/302/201/34. Full stop. It has emerged from the materials on record that after completing investigation into the case, Orang Police Station case number 55 of 2011, the IO, investigating officer, had submitted a charge sheet under section 17332 CRPC, by charge number 61 of 2011 on 30/11/2011. And in the said charge sheet, comma, the IO charge sheeted two accused persons, comma, one, Syamal Paul, that is the present accused appellant, and two, Sumitra Paul, finding a case finding them responsible for the offenses under sections 120B, 302, 201, 34 IPC. Full stop. As no materials were found against the third, against Sudhir Paul, comma, who was also named in the affair, comma, Sudhir Paul was not charge-sheeted. Full stop. After submission of the charge sheet, comma, the case, GR case number so and so, stood committed to the Court of Sessions, Udalguri, for trial. Full stop. And accordingly, comma, Sessions case number so and so stood registered. Full stop. During the course of the trial, comma, the prosecution side examined 6 number of witnesses to bring home the charges. Framed against the two accused persons, comma, on 8/2/2012, comma, under sections 120B, 302 stroke 34, comma, IPC. Full stop. After conclusion of the trial, comma, the learned trial court delivered a judgment, an order on 19/7/2012, convicting both the accused persons, comma, one, Syamal Paul, the present accused appellant, and Sumitra Paul, A1 and A2. Under sections 302 stroke 120B stroke 201, comma, IPC, read with section 34 IPC. And they were sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 50,000 each with default stipulation. Full stop. Aggrieved by the said judgment and order of conviction and sentence, said judgment and order dated 19/7/2020 of conviction and order, comma, both the convicted accused persons preferred a joint appeal before this court, and the said appeal was registered and numbered as criminal appeal number 83 within bracket J of 2012. Full stop. The said appeal was heard by this court on 2/9/2015, and the judgment in the said appeal was delivered on 19/9/2015. Full stop. By the judgment and order dated 19/9/2015, comma, this court set aside and quashed the conviction and sentence passed against the accused, passed against Sumitra Paul, comma, the appellant number 2 therein. Full stop. While acquitting Sumitra Paul, comma, the appellate court, as insofar as the conviction and sentence passed against the present accused appellant is concerned, had observed that the trial court, without recording the evidence of the autopsy doctor, relied on the post-mortem examination report. Full stop. It was observed that when the post-mortem report was available, comma, the autopsy doctor ought to have been examined to ascertain the cause of death of the deceased. The case was remanded back to the learned trial court for fresh decision against the present accused appellant, comma, Shyamal Paul. After recording the evidence of the autopsy doctor who performed the post-mortem examination on the dead body of the deceased, comma, Uma Paul, and to write a fresh judgment thereafter. Full stop. After remand of the case to the learned trial court, comma, the trial court examined the autopsy doctor as PW7 on 25/7/2017. Full stop. And present accused appellant was examined under section 313 thereafter providing him on 22/12/2017, providing him the opportunity to explain the circumstances appearing against him from the testimony of PW7. Full stop. After hearing it was thereafter the learned trial court heard the learned public prosecutor and the learned defense counsel. Full stop. After hearing them and after hearing the learned counsel for the contesting parties and after perusal of after appreciation of the evidence stroke materials on record, comma, the judgment and order impugned herein was delivered. Full stop. Para. Delivered. Finding the accused appellant guilty for the offense of murder under section 302 IPC. Full stop. Hence, the instant appeal. Full stop. We have heard Mr. M. Learned amicus curiae for the accused appellant and MS B. Bhuiya, learned senior counsel and additional public prosecutor for the respondent state, comma, assisted by MS M. Chakraborty. Full stop. Mr. Para, Mr. Dr. Learned amicus curiae, appearing for the accused appellant, has submitted that the case of the prosecution rested on circumstantial evidence, and as such, comma, a duty was cast on the prosecution to establish all the circumstances by cogent and credible evidence. Full stop. But in the case in hand, comma, the prosecution did not establish as to when the deceased had died. And full stop. It is his submission that it is neither clear from the testimony of the autopsy doctor PW7 nor from the postmortem examination report EXT2 that the case, the date of the disease, comma, Umapal was a homicidal one. Full stop. He has assailed the testimony of PW1, who was the informant, who was also the informant, comma, as a hearsay one. Full stop. It is his contention that the last seen together theory, which is a relevant facet in a case based on circumstantial evidence, was not proved. as nobody had deposed as regards as to when, as to whether the disease and the accused were seen together at any point of time. Full stop. The prosecution has sought to base its case on some doubtful extrajudicial confession. Full stop. As there were many gaps in a chain of circumstances, the learned trial court, according to him, had erred in convicting the accused appellant as the assailant of the deceased. Full stop. With such submission, he has contended that Mr. Doctor has contended that the learned the judgment and order of conviction and sentence of the learned trial court is not sustainable in law. Full stop. Para opposing and the contentions of the learned amicus curiae, Ms. Bhuiyan has strenuously contended that from the post-mortem examination report, it has clearly emerged that the date of the disease was a homicidal one. Full stop. Apart from the extrajudicial confession made by the accused before witnesses, who had no enmity with the accused, the relationship which existed between the marital relationship which existed between the deceased and the accused appellant from a motive had clearly emerged. Full stop. As it was at the instance of the accused appellant, the deceased had gone to Urang at the relevant time for medical treatment, the prosecution had been able to establish that in all possibility, it was the accused appellant and none else was the probable assailant. Full stop. Contending so, Ms. Bhuiyan has submitted that the judgment and order of the learned trial court needs no interference. Full stop. We have really considered the something. Huh? Okay, full stop. Which has Ms. Bhuiyan has further contended that the dead body was recovered at the instance of the accused, and such fact is admissible in evidence under the rule of evidence embodied in section 27 of the evidence. Motive already said. We have duly considered the submissions of the learned counsel for the parties and have gone through the testimony of the prosecution witnesses testimony. Examined by the prosecution and the documentary evidence laid during the trial to bring home the charge against the accused. Para. In the course of the trial, the prosecution side initially examined 6 number of witnesses and later on, another witness as PW7 to bring home the charge of injuricide against the accused appellant. Full stop. In addition, the prosecution side also exhibited 2 number of documents, PIZ 1, EXT 1-FIR and 2, EXT 2 post-mortem examination report. Full stop. The informant Bivas Chandrapal, as mentioned earlier, was a brother of the deceased and the brother-in-law of the accused, and he was examined as PW1. Full stop. PW3, Binoy, Durga Paul is an elder brother of the deceased accused and the brother-in-law of the deceased. Full stop. PW2, Binoy Pal was the PDP secretary at the relevant point of time. Full stop. PW4, Shiden Paul is an uncle of the accused. Whereas Vijay and PW5, Sunil Paul was a cousin brother of the accused. Cross, Durga Paul is my uncle's son. Full stop. The prosecution witnesses this PW2, PW3, PW4 and PW5 are inhabitants of a village Alisinga, police station Thekiajuli. Full stop. At the time of lodging the FIR and at the time of deposition, the informant dash PW1 stated that he resided in Thekiajuli, police station, Thekiajuli. Full stop. Where? কিছুমান বাদ দি দিম কিছুমান প্ৰথমে লিখি দিম 25 আৰু evidence sequence.
Evidence.
What is your disclosure statement, madam?
Because CD is not there, whether it was available or not, my
No,
lord.
he is not exhibiting anything.
My lord.
He is not exhibiting anything, not saying anything.
My lord.
Admittedly, the case in hand rested on circumstantial evidence, as there was no eyewitness accounts. Full stop. None of the prosecution witnesses had deposed to the effect that they had seen the alleged assault on the deceased by the accused. Full stop. It is a well settled proposition of law that that in cases where the evidence is of a circumstantial nature, the circumstances from which the conclusion of guilt is to be drawn are required to be established by reliable and credible evidence so as to exclude any hypothesis regarding innocence of the accused. Full stop. The Honorable Supreme Court in the case of Sarad, Bidis and Sarda versus State of Maharashtra are reported in 1984 4 SCC 116, has observed in the following manner. Where are 152, 153, 154. Has referred to 5 principles to constitute the proof of a case based on circumstantial evidence in the following manner. Paragraph 152, 153, 154. Before There are sets of judgments along with the case record.
Yes.
I think it was heard earlier sometime or no, about 7, 8
No, once
judgments.
it was heard by court number 5,
Ah,
Lordship, I said that the similar set of evidence which was in favor of the other acquitted accused will not be
Brathi.
brought. So Lordship,
I,
it was heard.
I
yes,
have seen Brathi
my lord.
and so many judgments.
Lordship.
Before analyzing, before an appreciation, before appreciation of the evidence on record, comma, a reference to the rule embodied in section 25 and section 27 of the rules embodied in section 25 and section 26 of the Evidence Act. Appear necessary. Full stop. Rule 27 will keep it. As per section 25 of the Evidence Act. No confession made to a police officer shall be proved as against a person accused of any offense. Comma, meaning thereby, comma, a confession made to a police officer cannot be admitted in evidence. Full stop. No confession as per section 26. No, section 26 of the Evidence Act has provided that no confession made by any person while he is in the custody of a police officer shall be proved against such person, unless it is made in the immediate presence of a magistrate. Full stop. Section 27 of the Evidence Act is an exception to section 25 and section 26 of the Evidence Act. Full stop. It makes that part of the statement which distinctly leads to discovery of a fact in consequence of the information received from a person accused of an offense, to the extent it distinctly relates to the fact thereby discovered, admissible in evidence against the accused. Full stop. The fact discovered must lead to recovery of a physical object like a corpse, a weapon, etc. Full stop. It is also relevant, pertinent to refer to. It is also pertinent to full stop. The rule embodied in Section 60 of the Evidence Act is to the effect that the oral evidence must be direct. Oral evidence must, in all cases, whatever, be direct. That is to say, if it refers to a fact which could be seen, it must be the evidence of a person who says he saw it. Semicolon. ঠিক টেনেৰে বাকিটা লিখি দিব। Full stop. As a corollary, when a statement of a witness is not based on a personal knowledge, but on what he heard from others, is termed as hearsay evidence. And a hearsay evidence is not admissible. And such a hearsay evidence is not admissible. Full stop. It is by taking into purview the above positions of law, we now turn to the testimony of the prosecution witnesses, excluding the admissible part of their testimonies out of consideration. Whatever is hearsay, we'll exclude. Otherwise, unnecessary wastage of thinking. Where? Evidence in chief, PW1 stated that he knew the accused as marriage was solemnized between his sister and the accused about 12 years earlier. Full stop. He stated that no issue was born out of the said wedlock. Full stop. PW once stated that the accused used to torture his sister, used to torture and threaten, used to torture his sister, and he also used to threaten her of killing. Full stop. The accused remarried one Sumitra Paul, and thereafter, the intensity of his torture upon the deceased increased. Full stop. According to him, he stated that on 24th day of October, the accused took Soma Paul to Orang on the pretext of getting her medically treated there. When Sumapol did not return, Durgapal PW3, the elder brother of the accused, came to his house to inform that Umapol had not returned to house. Full stop. PW1 stated to have informed PW2, then VDB secretary, who, in turn, told PW3, VDB secretary, PW2, who in turn told PW3 to search for the accused. Full stop. PW1 further stated that PW1 further stated that PW3 found Durga upon the accused and he, within bracket PW1, was told by on the accused, and the accused told that he, along with he had killed Umapol. So on getting the information, he lodged the affair at Urang Police Station. And he exhibited the FIR as EXT1, which is signature therein as EXT11. He stated that the police recovered the dead body of his sister, Umapol. In cross-examination, PW1 stated that the FIR was written as per his version. He further stated that during her lifetime, Umapol did not lodge any case. As regards any torture meted to her by the accused. PW1 further disclosed that after his marriage, second marriage, the accused kept Umapol at his own house at Ali Singha, and he used to live separately at Orang. PW1 also stated that the accused had 3 brothers. PW1 further disclosed that he lodged the FIR on the basis of the information received by him from Durga Paul, put in bracket PW3. PW2, Binoy Paul, stated that he knew the accused, and at the relevant point of time, he was the PDB secretary. On the incident, PW2 deposed that on one day, Durga Paul PW3 came to him to inform that Umapol did not return home. He then made a charge for Umapol. But after about 7-8 days, Durgapal PW3 apprehended the accused and brought the accused to his house. When he questioned the accused, the accused stated to have admitted that he killed Umapol. Full stop. Then, he, PW2, handed the accused, handed over the accused to the police personnel of Thekiajuli police station. Full stop. Then, he, PW2, stated to have informed Bihas Paul, PW1. And thereafter, the accused was sent to Urang police station from Thekiajuli police station. Full stop. And during cross-examination, now whatever deposed by PW2 during his cross-examination was in the nature of hearsay and was in the nature of hearsay. No, during cross-examination, Binoy Paul, PW2, the Vidif secretary, was then called and before Binoy Paul, PW2 also, the accused admitted that Uma Paul was killed by him. Then Binoy Paul, PW2, handed over the accused to the police station. Full stop. During cross-examination, PW5 stated that Durga Paul, PW3, did not tell him anything when he brought the accused to his shop on that day. And as such, he was not aware as to why the accused had been brought. Accused had been apprehended. Full stop. On an analysis of the testimony of the aforementioned witnesses, it has emerged that the marriage between the deceased Umapol and the accused was solemnized at least a decade earlier to the incident. Full stop. According to this prosecution witness, it has further emerged that the accused had entered into a relationship with another woman, leaving Uma Paul to stay in his original, in his house at his native place at Alisinga, where his elder brother, Durga Paul, PW3, his uncle, used to live. Poster. It has further emerged that according to this, according to PW3 Durga Paul, the accused had been living separately from his first wife Uma Paul in a rented house at Orang for a period of 3 years from the date of the incident. Full stop. The PW3 Durga Paul did not disclose in his testimony from whom in what manner the accused had called Uma Paul to Urang for the purpose of providing medical treatment to Uma Paul when, on that day, he was not at home. Full stop. From the testimony of PW1, it transpires that whatever he had mentioned in the FIR EXT1 was based on information provided to him by Durga Paul PW3, as he admitted the said fact in his cross-examination. Full stop. Does, his testimony to the effect that Uma Paul was taken. Uma Paul was either called or taken to Orang on the 24th day of October was clearly based on the information provided to him by Durga Paul PW3. And as such, the same is also in the nature of hearsay. As Durga Paul PW3, in his testimony, did not mention anything as regards the date when Umapol was called purportedly for providing medical treatment to Urang by the accused. Full stop. While PW Sri Durgapal had categorically asserted that when accused maid had admitted that Umapol was killed by him, he was alone and there was no other person with him. On the other hand, PW4 Sidan Paul stated that when Durgapal PW3 questioned the accused in his presence, the accused confessed his guilt. PW said so. Confession? One? PW1 said something.
No, PW1 said yes.
It's a
PW1
bit vague.
Wait, PW2 also said that the confession was made before him. So that is also inconsistent with what Durgapal was saying. The BDP secretary, he said that he was brought to his house and on question, he replied that he killed Uma. But he's saying that Durgapal is saying that he was alone.
PW2, Bina Paul, the BDP secretary, had stated that after Durgapal, PW3, after apprehending the accused, brought the accused to his house. From the testimony of PW2, it does not emerge that when the accused allegedly, when accused admitted before him that Umapol was killed by him, admitted that he, within bracket the accused, killed Umapol, Durgapal, PW3 was present along with him. Full stop. Yeah. From the testimony of the prosecution witnesses PW1, PW2, PW3, PW4, and PW5, it has not emerged clearly as to when the Umapol left her house at Alisinga for Orang. Full stop. Extrajudicial confession is a weak type of evidence and is generally used, is considered and it is only used as a corroborative piece of evidence to lend credibility to the other evidence on substantive evidence on record. To come. If it is not supported by other evidence on record, or if it fails to inspire confidence, comma, it shall not be treated as a strong piece of evidence for the purpose of arriving at the conclusion of guilt. Full stop. The standard required for proving an extrajudicial confession to the satisfaction of the court is on the higher side. Full stop. It can only be accepted after exercise of care and caution. Era? Ah. And before accepting any extrajudicial confession, comma, the circumstances surrounding which such extrajudicial confession was made are to be considered apart from examining its voluntariness and truthfulness. Full stop. If an extrajudicial confession does not inspire confidence of the court, comma, the same is required to be excluded from consideration. Full stop. Para. Resting, not para, resting the discussion here on this aspect, comma, we now turn to the testimony of the PW 7. Comma, who performed, oh, I'm sorry. Mr. Dotto, after 2, there is one judgment. There is one single bench matter. My sister is having one division bench. If time permits, we'll sit. Yes, if time does not permit, allow, then we'll post it on Monday.
Tomorrow is also been working day, ma'am.
Mass Puya is very reluctant. Has strong objection. Not tomorrow, because I would have no problem, but has some more matters in the single bench. Tuesday, then? Tuesday? Huh? Holiday. Okay, 5th. Okay, NJDAS, learned amicus query for the appellant, and MS Bhuya, learned senior consideration public prosecutor for the respondent state are present as sought for by the learned counsel for the parties. List the appeal on item number 5th. Item number 9. We'll see if time permits, we'll sit, or otherwise we'll post it as agreed by you on Monday. Not Saturday.
For pronouncement of judgment, item number 1.
তুমি লিখলে যেটা জানা লাগে, হ্যাঁ 18 করেছে আমার পর নিয়ে থাকে।
In the light of the discussion made above and the reason assigned therein, we do not find any reason to take a view other than the view taken by the learned trial court, which has reached the view that the prosecution has proved the case beyond all reasonable doubt. In such view of the matter, the appeal being devoid of merit is liable to be dismissed by affirming the judgment and order of the learned trial court. Ordered accordingly.
The employment actions certificate. So my lord will get the
rejection order at page 25.
Yes.
My lord, the applications of the following candidates who applied for the post of office assistant slash clerks contractual in the office of the Legal Aid Defense Council under District Legal Services Authority, Kamrup stands rejected. My name is at serial number 80, my lord. My lord, may kindly turn up to page 33.
Yes.
33, serial number 80, my lord, Krishna Kumari Das. The region of rejection is EERC not enclosed. So that is employment action certificate was not enclosed. But my submission is that, my lord, we have duly submitted along with my application, my lord, that EERC, because in my application, my lord will find my application, my lord, at page 23. The last page 23, the last para 14, my lord, that employment registration number. Even I have mentioned the employment registration number also.
Did you annex?
Yes, my lord. I've annexed it also.
Where is your
It
statement?
is page 24, my lord.
Where is your statement?
It is in my read petition, my lord, at para 4, my lord.
Yes, thereafter.
Thereafter, my lord, they have scheduled the Viva OC on yesterday, today, and tomorrow, my lord.
Hmm.
So basically, I've been excluded. My name has been excluded arbitrarily, my lord. And my humble prayer before your lordship is that I may be allowed to appear in the interview. That is a small request, my lord. That is the only prayer, my lord.
But subject to,
And even I have submitted my representation also, my lord, on 27th August. That was not considered, my lord. Page 62, my lord. Hmm? Yes.
yes, madam.
Lordships, I'm appearing for the State Legal Service Authority. Actually, the jurisdiction lies with the DLSA, Kamrup Metro. So we are not conducting the interview. Asalsa is not the authority to be conducting the interview. It is the DLSA. I'm not sure the government advocate should be here to represent the matter. But Lordships, in a overview of the matter, if what she's saying is correct, then she will be prejudiced if she's not allowed to appear. So I'll leave it to your
So,
lordships.
subject to further scrutiny about the eligibility of the petitioner, we can permit as an interim measure. Did you serve copies to them?
Yes, my lord. We have served it.
Their names are reflected.
DLSA
Yes, their names also reflected in the cause list itself.
So according to M.A. Chaudhary, it is government advocate
Yes, Your
who has to,
I do not appear for DLSA, Your Lordship. I only appear for the state.
what are respondents here?
Respondent number 2 is the State Legal Service Authority, and 3 and 4 are the Kamrup Metro
Yes.
District and Session, the Secretary of
She
the.
is to be represented,
3 and 4 are to be represented by the government advocates, Your Lordships. Each district,
okay, 3 and 4.
3 and 4. I only appear for 2, Your Lordships.
Okay, it is 3, why not standing counsel Guwahati High Court?
No, Your Lordships. By the government advocate.
Okay.
नाम तो जाना नहीं कब सब कौन सा नाम?
It's my direct officer.
Second COVID notice to this can yes and so.
It has been served to the office itself, my lord.
Yes.
Just few minutes ago, I have inquired that they have received the copy, my lord.
No? Okay. You are BM Decca.
Yes, my lord.
Okay. And MH Chaudhary, you are State Indian Council, Assam State Legal Services Authority.
Yes, Your Lordship.
For
Respondent
the
two.
respondent number 1 and
O- Only two, Your Lordship, not the legislative.
Only
body.
two.
Only two.
okay. Will permit and do you have any thing to convey the information?
Lordships, I can immediately convey this thing to the legal service authority here, and they can inform the DLSA that she has been permitted to appear tomorrow, I'm sure, not today.
Tomorrow.
yes.
Tomorrow.
Yes, Tomorrow,
Will permit.
I think the.
Subject to further scrutiny
Sure, for this.
about the eligibility
My
or
lord, my-
subject to further instruction placed by the respondent authorities as
long
an interim measure.
As long as the certified copy is there with my learned friend, that should
Okay,
suffice.
we can make it returnable by particular date.
Lordships. As per your lordship's convenience.
Today is because results are also going to be required to be
Yes, yes.
published.
Perhaps 12th or 11th of
We can make it 13,
lordships, 14.
13.
Some.
13 may turn out to be auspicious also for petitioner.
14.
39.
Banga also Saturday also.
Oh,
14,
yes,
9 is
yes,
Saturday.
yes. 12, 12.
Um,
If possible, my lord, 12 maybe.
Or.
No,
or could
Thursday
it
we
be-
are not.
Could it be 10th, your lordship, subject to your lordship's convenience, 10th?
Those are hearing days. I am sitting in division
Tuesday,
bench.
okay, lordship. Then
13th?
Wednesday, 11th, 12th, 11, 9, sorry, lordships,
Let it be on 13.
13th.
My lord.
13. Okay, we will issue notice returnable.
My
So permit the petitioner.
Much obliged.
And I will observe that he can download. It will be made available after say 4
Highly
today.
obliged, my lord.
Oh, lordships,
And if
that is
not,
just-
if you do not get it because of reasons beyond not my control,
My lord.
Of course, your lord.
office of the
I understand.
High Court, then you can download, I'll observe, you can download a copy from the portal and submit it to the authority.
My lord.
And authority after verification from the portal can permit you.
My lord.
And you also,
I'll
also observe that you will
I'll
convey.
communicate to the SALSA office that she's been permitted to appear tomorrow at 12 o'clock because that is the
Okay.
reporting time given to everyone, to all the candidates. So
Okay.
she should also report around that.
At 12 o'clock.
Okay.
Deeply
You'll get the
appreciate.
order.
Highly
today
obliged,
itself.
my lord. Much obliged.